Ladies and gentlemen of the jury, I wanted to bring to your attention what is going on in the United States of America. We have a President Biden who is a warmonger. He wants to fight nations against each other and bring in a third world war. And they wanted to sell in the process arms and ammunition to kill the Jewish people and the Palestine people. He forgets he has people grieving to get even their monthly social security benefits, for which we all struggled, we worked. That is our constitutional right. If you are a US citizen, you must get your social security benefits as passed by the United States Congress. But in my case, during the last 4 months, I have no pension, social security benefit from the SSA Gov. Now, the reasons are very simple. President Biden brought maybe 2,000 or 20,000 mules, as rightly described by Denise D'Souza. This is a banned video which is not available, and there was also, I am told, there is a video. So this is the one I got it. We will show you the short video which is banned, because we don't want the US electorate understand what the game going on there. Okay. In my case, as I said, last 4 months, no pension, no social security pension. Okay. And I was trying to speak to everybody. The instructions given in the form called 1199-IN stated what you have to do. Instead of sending me the money in rupees through the Federal Benefit Unit, they sent a check, thinking I am in USA. I didn't go to USA. I went to USA for 3 days. I got stuck in Atlanta, Georgia. I went to a hospital who was supposed to admit me. They didn't, although I had coverage for admission to a hospital. So I left that hospital because they were not giving me my medicine, my regular food or anything except 1 day. So I took a plane back to India. You have to understand the way the things are going. These morons in the system, in the SSA Gov, got all screwed up, because you have to go through a cumbersome procedure. You are supposed to go to the US Embassy, but we don't have a US ambassador yet. One person by the name Garcetti was nominated, but the Republicans blocked him. So we don't have a US ambassador. Everything is handled by Federal Benefit Unit in Manila, Philippines. They open only 2 hours, Tuesdays, 2 hours their time, and 2 hours Tuesday and Thursday, 2 hours each. You can talk to them. And even if you talk to them, you get no answer. So as of this moment, I have one bounce check issued by the Social Security Administration, which I presented through my bank, and that got bounced. And I was called upon to pay $25 bounce check fee to the bank here. You have to understand. Now the problem is, we have so many intermediaries. One is the Federal Benefit Unit. Another one is another agency called International Operation of the SSA Gov. And they all do not know what they are doing. Okay. Now, there is a reason why the problems. When I was working for a company by the name Michigan Bell Telephone Company, I was subjected to all kinds of discrimination. I was subjected to all kinds of discrimination by this company. We started with a gender discrimination, a national origin discrimination, which led to other problems. I reported that time to the U.S. Department of Justice, known as EEOC. They came and investigated, found the employer guilty of discrimination. Is a spy? Okay. All right. Because everybody may come in the form of a bird. They may take different shapes. I trust nobody. Now the spy is gone. All right. So it was a spy in the form of a bird. Now that is designed to distract me from what I am saying. That case was investigated, found the employer guilty of discrimination based on, as I said, based on national origin, color, gender. The EEOC investigated, found the employer guilty, and ordered them to pay me $1,000 compensation as a token and to reinstate me. I was reinstated, sent to work for 4 people. One is a German, one is an American white, one is a black American, one is a French. All of these people found me shortly overqualified. The white gentleman by the name Hank Hudson recommended me to take a management assessment program for 3 days, in which I got a perfect score. But Michigan Bell, hereinafter I call MBT, they refused to disclose even the test result for 1 year until I requested in writing. So one Mr. Shepherd came to me and said, "Mr. David, come over to me, I will tell you what happened." And he said, "Mr. David, you got a perfect score, but we can promote you because you complained about us to the EEOC. So as a retaliation, they refused to provide me promotion or training as required and as given to others of similar standing. I filed another complaint for retaliation, and as a result, I was sent to work for their then parent company by the name AT&T. AT&T had an agreement to ship my 2 cars household furniture, everything to Florida, and also to do likewise when I am returned back to go to. So what I'm saying is, the bird gone, the spy bird. Now we get another spy on the phone to change my thinking. Okay, they try every tricks. This sucker company, AT&T, had dubious plans. They called me on the phone first, and they interviewed me. They asked me to join them as from April 1, 1979 for a period of 5 years. You have to understand, they have a contract to retain me in Florida in their monopolies division, where the Department of Justice of the United States wanting to break up this company because they were a sole monopolist in the United States at that time. I'm talking in the 1980s. So, a lot of relevant things which I want you to tell. At that time, President Reagan was running for office, and a priest, Catholic priest, from a broken family of 6 boys and 6 girls, by the name Raymond J. Donovan, he contributed to President Reagan's coffers, election coffers, I believe $6 million or 600,000. I'm not sure. It's all in the history. So President Reagan felt very happy, and he nominated Raymond J. Donovan as his Secretary of Labor. Okay, you have to understand the background. As soon as Donovan was confirmed by the Senate, you can see the proceedings in a company called C-SPAN, C-SPA. So it's all in the record. It's about 2 hours proceedings. President Reagan appointed him, the Senate approved, he took over. And we learned later, at the time, he was a member of the mafia, Genovese mafia. He busted unions. He encouraged child labor by giving them 50 cents an hour. Okay? So another spy is coming here somewhere, another form. Okay? Where is the spy coming? This is a different form of spy. Okay? The objective is to prevent me concentrating what I am doing. Okay? So, this Secretary of Labor was found doing a lot of things as I explained. He was forced to retire, forced to resign, not retire, resign. First Secretary of Labor in the United States government in the history, who was forced to retire or forced to resign, and the party who benefited most was AT&T. It is all in the record. There was an article written by a professor from the Loyola University, the impact of AT&T's divestiture, how they destroyed families. It is all in the video. So, what I am saying to you, gentlemen, ladies and jurors, here there is a big problem. They deployed every kind of fraud. The Michigan Bell called me to a meeting in which I was offered $45,000 to quit their job. I had at that time 4 children, 3 girls and a boy who is born in USA. The girls were born in England. And they were aged 3, 7, 9 and 12. My wife is unemployed, although she was a registered nurse from England. She was taking care of them. It created havoc, problem. So when Mr. Richard Stone offered us the money, which is 45,000, I told him, sir, we don't want the money, I've got small kids. Then he got up and said, Mr. David, you are fired. AT&T was a federal contractor. They can't fire an employee without a cause. It is a violation of the law. They fired me at the age over 40. So there is a law called Age Discrimination in Employment Act. They call it ADEA. There is a regulation by the IRS, 10-4, which requires certain requirements. They don't care. Okay? So they're fired. I had no option. I had to sign the release under duress. But the release I signed, which is shown as Appendix 1. It's a 2-page release. The release was signed in the presence of a former attorney for this company, Michigan Bell. His name is Jack F. Gardner. You will see page 1 and 2 of this document. Then they fired him. Okay, you have to understand. Now they are required under the rules to provide you a right to sue letter. The company was reported first to the EEOC in Orlando, Florida. They don't want to conduct an investigation to find out how they treated the 1,500 minus me, how they treated them differently. I am differently. Why? So this company, the EEOC, which is part of the US Department of Justice, issued me a right to sue letter, which is Appendix 2, and I commenced an action. This was given dated April 12, 1982 from the Equal Employment Opportunity Commission. Then I filed a pro se action. It means I am acting my own as my lawyer, and the defendants brought in a motion to dismiss my case, interposing release as a defense. Shortly afterwards, I went to Chicago, found an Indian lawyer who is practicing as an advocate in Cook County, Chicago. They offered him an offer to become their lawyer, which he refused. Then they offered him first a judicial position in Cook County, which he declined. Then they offered him some cases to handle on their behalf, which too he declined in my presence. I heard him say, not interested, 2-3 times. He hung up the phone. He came to Florida along with me, spoke to my wife and children to find out whether I am lying whether I resign the job or I am fired. After having convinced, he filed an amended complaint. The amended complaint is shown as Appendix 3. There are there are 5 pages. We have 7, 8, 9 pages, 10 pages. There are 11 pages of his complaint. You can see how he filed the amended complaint. We will see, you can see as we go through. Anybody wants to do research, you can get this. Then, after he filed the complaint, he wanted a lot of money as a retainer, which I couldn't afford, because I was going through a divorce from my then wife, sister. So, the defendants were trying to bribe my lawyer, didn't work. I couldn't afford to pay him. I took over the case. You have to understand? Pro se. Then we learned the judge, John Reed, was meeting the opposite party's counsel, which was a young woman by the name Ann C. Conway. And the reason was, why they wanted to bring this woman was, they wanted to influence Federal with the judge. Okay? Her name is Ann C. Conway. You will see her. You will see the judge, John Reed. Okay, he is one of the more than 100 judges involved in this case. Okay? I am not President Trump. He might have hundreds of cases. But in my case, we had more than 100 judges in one case. A violation of the Title VII of the Civil Rights Act, ADA, and breaches of contract. Why we need so many judges? Okay. The Supreme Court of the United States eventually granted me granted me my petition for a writ of mandamus. Before the court granted the writ of mandamus, several things happened. The judge, John Reed, who was meeting this young woman, Ann C. Conway, at her home, he was forced to recuse and resign. Okay, why? They were doing everything in flagrant violation of the canons of ethics and professional responsibility. A trial judge and his former law clerk can't meet each other at their homes and other places in Atlanta. They were trying to fix the case. You understand? The judge was forced to recuse and resign. You will see a copy of his resignation from the bench, this judge. Now, normally, when you have a litigation going on, you are required to get a discovery. Judge Reed was forced to resign from the bench. I reported him first to the FBI in Orlando and to the Chief Justice Warren Burger of the Supreme Court at that time. As soon as Justice Burger got this information, he ordered Judge Reed to recuse and resign. So you will see the copy of his order recusing himself. Now they have a deal with another judge of the defendant's choosing. His name is Terrell William Hodges of Tampa. Tampa had no jurisdiction over me. I never lived in Tampa, except that I once went to Clearwater, Tampa, with my children to do fishing for an hour. That doesn't confer any jurisdiction over this judge. Issued an order. Mr. David, come down to my court for a conference. When I went there, she treated me as if I am a wanted criminal in a criminal court proceedings. On the notice board, he stated, additional security required, and no other hearing on that day in his courtroom. And I walked in, on my left, right, and the middle, one person there, a gun wielding, on the right, another guy, somebody on my back. I am trying to enforce the laws on the books. This is a civil case, an ADA case, a Title VII case, not a murder case. Okay? I was cleared previously by the FBI, and I started working for the Internal Revenue Service Appeal Division in Miami. You understand? So this guy is a paid puppet to the corporation, Hodges. Okay? Hodges won't allow me to speak to him. And in the meantime, AT&T and Michigan Bell created a case law. The case law says you have to tender back the money to the employer. They had paid me the money when I was in Michigan in 1981, okay, which I signed under duress, coercion, and through fraud, because I had no means whatsoever to feed my children. So this judge, who treated me badly and without any hearing notice, issued an order, Hodges. The order is not with regard to my claims for Title VII, ADA, ERISA, but a tender back which these companies had created by terminating another employee by the name Orville E. McDonald, by paying him $12,000 and dismissing him. He was a division manager. So created case, thumbed up case to get a way to escape. So the clerk of the court, the Hodges order was dismiss the case without prejudice based on the tender-back defense. Tender-back is a novel proposition brought by these companies first time. As a theory, it is a novel case. The Supreme Court of the United States held there is no need to tender back the consideration until after a hearing and a trial. The name of the case is Aubrey versus Endergy. So the defense So the scheme was, Hodges issued an order based on the tender back, which is not the issue before the court, and he stated in his order, dismissed the case without prejudice. You have the expression, without prejudice. The clerk of the court, deputy clerk, Donald Brown, altered that and entered a judgment as on the merits. There are wide differences between these two terminologies, such as without prejudice as on the merits. The defendant's counsel, Peter Wolf Silver, filed false affidavit telling the case is final and on the merits. That's not what the court had stated. To dismiss the case without prejudice, Peter Wolf Silver filed a motion, a jurisdictional statement, saying the other way. And this woman, Nancy Conway, then a lawyer, came to argue the matter before the 11th Circuit, which was specially selected by the insiders. They decide which panel should get the case. It's not one or two or three judges. There are maybe 20 or 30 judges. I don't remember how many at that time. So they pick and choose which panel should hear it. The panel affirmed without opinion the order so procured through fraud without opinion and entered mandate. You will see the mandate issued by the court. Okay. So the 11th Circuit Court of Appeals issued mandate. The issue before the court was my Title VII. Nobody tried that case. We are talking about the tenderback issue, which was doctored by Peter Wolf Silver, filing a jurisdictional statement. Jurisdictional statement is Appendix 8. He says here, the Court of Appeals for the 11th Circuit has jurisdiction to hear the appeal under the authority of 28 U.S.C. Section 1291, in that the appellant seeks review of a final decision of the United States District Court for the Middle District of Florida, which entered summary judgment as to all of appellant's claims on January 9. I can't even read the rest. Okay, that's the order of the court. It was submitted by Peter Wolf Silver, attorney, and the entire lawyers of both AT&T and Michigan Bell. So they were lying. Okay? The court's order was to dismiss the case without prejudice. The clerk altered it to procure the jurisdiction of the 11th Circuit. And the court, as I said before, entered a mandate by Robert Vance and Edmondson, circuit judges, and all good. Okay? Folks, you have to understand the name of the going on here. Now, Edmondson was asked in the appeal in case number 86-3656 SS, and he denied the motion. The issue I raised was, in my FRAP 35 is why there is a difference in the ruling when the court has no jurisdiction to consider my claims under the ERISA Title 7 claims. No response. You understand? So the name of the game here was to decide my case based on fraud committed by the clerk of the court, Donald Brown, who was later on dismissed by two judges, Kendall Sharp and Patricia Fawcett of the same court, Tampa court, because he was doing the same thing, taking money under the table. How much you pay, you get the panel, which judge you wanted. That's the name of the game going on all the time, including President Trump's case. You understand? Now the US Department of Justice is supposed to investigate. Now they say in their various letters, Mr. David, we have no jurisdiction. Okay? We have no jurisdiction. The case was appealed to the Second Circuit Court of Appeals, and John Walker, Rena Raggi, and both district circuit judges and Judge Rakoff, district judge, affirmed. Okay, that's their order is dated December 17, 2009. Okay. Now, when a court issued an order, they should make a ruling. The ruling in the case is disappeared. How can a tilker who is 2 years old submit a false affidavit to the court, and on the basis the court grants a summary judgment? So the law firm who filed the papers, they are in trouble. The law firm was the Fulbright and Jaworski. The investigation is still going on there. As of yesterday, we checked, there is no ruling. How a 2-year-old child living in New York can testify what happened 800 miles away in Michigan, and on the basis of that, the Judge Seibert, Joanna Seibert of the Eastern District of New York, can render a judgment. No response. She granted a summary judgment without giving me any discovery whatsoever. You will see the colloquy between me and this woman and Mr. Dawson on the phone. I am in the court. The tilker nor Dawson never ever came to the court to file any papers. I never met them in my life in person. They accomplished everything what they call through the Charlie's Angels. It means the intermediaries. You must have seen the Charlie's Angel, the movie. So they accomplished their mission. Okay. As of now, no investigation against Dawson or the 2-year-old tilker who fled to Hawaii, the safe haven for the Democrats. And when I chased him and I reported him to the Bar Council there in Hawaii, they said he has not been licensed to practice there at that time. And they said you should continue with Bar Council in New York, which they are doing. In the meantime, Tilker got license to practice before the Supreme Court of the United States. How did he do that? He must have lied throughout. When you get license to practice in another jurisdiction, they are required to verify whether there is a pending case against him. Okay? So, he formed a corporation, Fox Pickle LLP. Alright. Now, they don't want to take any action against him. How he got managed? These are the questions. There is no answer. I filed a petition before the Supreme Court of the United States of America. The Supreme Court granted me permission to file a petition in re Telecoto, case number 16-9624. Now, once the court got it, they are required under the rules to send a copy by express mail. The clerk of the court, possibly Atkins, didn't do that. He affixed a 93 cent postage, thinking India is the local country, or he pretended. So, pursuant to the court's order, which came to be sometime at the end of December, I believe, I submitted my $300 bank draft, 65584, that is the court fee, submitted to the court. So, the first clerk, by the name Melissa Blaylock, returned that, saying that the case dismissed the letter, the case. I have here a letter from the Blaylock, dated Appendix 16A. It is dated January 17, 2018, showing on the top in re Talakotu number 15-9100. That was a case dismissed by the Supreme Court earlier, allegedly for lack of jurisdiction, and they were wrong. So that's why I submitted this brief. It was received by her, and she returned with the fee in 4 boxes. You understand? Her ignorance to read and understand the court's order is not my fault. I tried to call this woman on her number shown here, case phone number 202-479-3023, Appendix 16A, and she won't answer. I kept calling at least 2 or 3 times at different days, different times of the day, and she won't answer. I sent my bank draft, Chief Justice Roberts, in turn, sent the bank draft Jeffrey Atkins, the major player, the one and the only one. He corrected the case number as 169624, and he returned the check again, saying that court dismissed the case. You have to understand, he can't read English. The docket sheet of the Supreme Court, you will see the Supreme Court's order said certiorari, summary disposition, and my case was not in the denied list. The list denied it. My case 9624 was missing. And in another place, the court granted. But these two morons pretended the court dismissed the papers. Okay? Then this moron's number, Jeffrey Atkins, wrote a letter saying, Mr. David, they have my address, phone number, everything there. He says, under Article 3 of the Constitution, the jurisdiction of this court extends only to the consideration of case or controversies properly brought before this from the lower courts in accordance with the federal law and filed pursuant to the rules of this court. Your papers are returned herewith for the reasons stated in the January 17, 2018 and February 6 correspondence. This moron, he is interpreting the rules, he is telling what the other woman did. The first woman, blah blah. She is writing a letter and he is saying he is rejecting. You understand the name of the game? Then I asked him, when I requested him in writing, under article, the Constitution doesn't apply here because I had filed my papers on time and the EEOC had taken my complaint. Then he issues another letter. It says September 10, the papers pertaining to the above entitled case received September 10, 2019. He didn't get the papers to September 10, 2019. Okay, they got it in January. Okay, so what he is trying to do is to show the case was filed in September 10, 2019. Understand? And what he is saying is returning again and the money back. Okay? He is a clerk of the court. His job is purely ministerial. Under Rule 1 of the Supreme Court rules, he has no option but to carry out the orders of the Supreme Court. He is not the lawyer for the defendants. The defendants, AT&T and Michigan Bell, never raised such an objection. How can the clerk of the court raise an objection on his own overruling the Supreme Court of the United States of America? Then I made a motion under Rule 22 of the Supreme Court rules. I sent a letter to the clerk of the court, which was received by him on September 10, 2019. As you see it here, we will see the close-up. And I sent a copy to Leon Lee, Counsel of Record, Appendix number 20, and he didn't, and also we submitted another fee, Appendix 21, for review by Justice Thomas. They never showed him this one. I paid the fee second time for review, never shown to him. Maybe Atkins was not showing these papers to the chief clerk. Chief clerk is a person with a Juris Doctor and other qualifications. Okay? Under the fraud system, he may not be knowing what is happening. Then, on September 10, again, Jeffrey Atkins stated in his next letter, the papers pertaining to the above entitled case received September 10, 2019 are returned for the reasons stated in the February 16, 2018 correspondence. The case is considered closed in this court. Your 300 check is returned for the second time. So the name of the game here going on in the Supreme Court is the clerk of the court is controlling, challenging the Supreme Court of the United States of America. Then I took them to the disciplinary committee of the bar. There, the chief prosecutor's name is Hamilton Fox III, disciplinary counsel. And this was shown as Appendix 22, and it says Ray Harris David, undocketed, case number 2018 letter U 667. And this doesn't go to the chief prosecutor. This goes to a senior assistant counsel. Okay, she refused to entertain for the reason we declined to open, which says open full investigation of this matter because your concerns describe Mr. Harris' duties as administrator of the court. If Mr. Harris declined to act on your concerns or submit your motion, this was part of his official duties, which include accepting or rejecting submission to the court. We do not have the authority to determine whether Mr. Harris should have behaved differently under the circumstances. Accordingly, this matter is now closed. Thank you for raising this for our attention. Okay? This is the name of the game. The Supreme Court's order goes to different people, different places, and nobody can understand. Nobody can understand the clear, unequivocal orders. You understand? So the name of the game is to prolong my agony until eternity. This slut, pardon my French, she says in her next letter, we received your correspondence requesting a second review of the disciplinary complaint that you filed against Scott Harris. Our decisions are final and not subject to further review. See Board Rule 2.4. However, we have considered your request and there are no new facts sufficient to change our decision. Therefore, while we appreciate your concerns, we decline to reopen this matter. This is the second letter from the disciplinary council of the bar. Did I get a discovery? Did I get a response allegedly filed by Scott Harris? No. This is a one-way traffic. They concoct stories, and on the basis of the story, they conclude whether the Scott Harris did right thing or not. His job as a lawyer, as the clerk of the Supreme Court, is to ensure the orders of the Supreme Court are properly interpreted and applied. Can't he understand? He understands. Okay? So folks, then Mr. Ralph Curtis Dawson, got an order from this woman. Her name is Giovanna Seibert. She had absolutely no jurisdiction to consider my ERISA, my Title 7 and ADA claims. But what she does is, she thinks she can do whatever she wants. She is a judge of co-equal powers. She is only a district judge. So she issues an order to keep, she issues an order. She says, you guys, Florida, Tampa, send me all your papers. Does she have the authority to do so? She is not an appeal court judge. She is a judge of same title and jurisdiction. But she thinks with the enormous power, the chairman of the Democratic Party's Rules Committee, Herald, send them. So these people, the Judge Reed and Hodges, both are dead, I don't know at that time or later, ship their papers to this clerk, pardon my French, and she decided, Mr. David resigned the job. Did I resign the job? They fired me, okay? So she issues an order, 20 page, how many years here, 16, 17, 18, 19, 19-page order, okay? She issues a 19-page order based on hearsay evidence, because no hearing, no trial in her court. As I said before, neither Tilker nor Dawson ever came to the court. They were accomplishing everything through the Charlie sages. It means intermediaries going them, giving money under the table. I can prove it. It's the job of the FBI to find out. So if she issues an order, I filed a motion for reconsideration. So she says, in my motion for reconsideration, I showed that at the time Tilker submitted the affidavit, he was only a child of 2 years old. How a 2-year-old child, now an attorney, submit an affidavit testifying his personal knowledge? Because the release that I signed was in Detroit, Michigan, on August 25, 1981. How Tilker, who is 2 years old, how does he know? He is sitting 800 miles away in New York. And the party chairman filed these false papers. Mr. Curtis Dawson, Ralph Curtis Dawson. Her case is pending now. After all these years, they know they can't overcome the heavy burden. How, the question is, how a 2-year-old child, Tilker, learned. I executed a release about which he says in his sworn affidavit he has personal knowledge. Folks, all these are fraudsters. She granted the order which was affirmed by the Second Circuit without opinion. Okay. Now we ask the court, where is the court's order? They have no idea. Where is the order? If a court issued an order and I paid $545, right, for the copy, and there's no order. So what happened to the order? That's why, folks, the Supreme Court comes into the picture the action is pending as of November 30, 2023 with the Attorney Grievance Committee which was Appendix 26. Okay? So, folks, I presented to you my case. It is for you, the civilized world, to understand the name of the game going on. So far, no pension for the month of March, April, May, June. Okay? How, Mr. President Biden, you are running the mules, the 20,000, the other author said, D'Souza stated, how are you getting all the mules? We tried to download. I spent sleepless nights, not one day, practically 2 months trying to get. Nobody knows. Where is my money gone? We just called the bank whose account is in the system. They don't have the money. One check got bounced. Second check, I sent it back to the federal international system, thinking they might have, and I don't know what happened. Nobody knows. Where is my pension? President Biden must find some qualified people to run the system. How he feels if he doesn't get his salary every month. I have employees. I've got people to working for me. My wife is 71. I'm going to be 85 next month. You understand? This is the what they call the fucked up American system. The most Biden can do is either block my videos or come and send some undercover agents, pick me up and kill me. That's what they do. They did it with one federal judge in the Court of Appeals. He was found, Clarence Allgood, he was found dead in his bedroom with a gun nearby. Why a federal judge, an active federal judge found dead? Because he may not have contributed to what they are saying. So the best way is to get rid of him. The FBI made no investigation, and apparently they concluded he committed suicide. Why should a sitting federal judge commit suicide? They murdered him. They don't want to admit it. They may be, as I understand, they are trying now to do the same thing with the Supreme Court judges. You understand? When they apply, interpret the law, then allegations come on after the other. This guy judge, this judge so-and-so did this, that judge went for a trip with somebody. All this is coming up now. How Politico got the news when justices were sitting in their chambers discussing how they got it, that news. What is the investigation? They couldn't find out how they leaked, right? Folks, I want to thank you all. I want the civilized world to understand the American politics. It's not a just system. The Congress, we have nice congressmen and senators. They know they pass the laws for the betterment of the people. They were elected, and the Supreme Court of the United States interpret the laws based on the laws passed by the Parliament, the Senate and the Congress. but corrupt people get away. Hope people all over the world will rise, and anybody who wanted to make this a thriller video, movie or series, come to me, call me, and I am ready to listen to all of you. Okay? But nobody will. The procedure is, it is like the camel cannot pass through the eyes of the needle. Everybody is afraid. Okay? Thank you, ladies and gentlemen, taking the time, and we will meet again soon. Thank you. My email address, as we said, trdavid2009@gmail.com. You will see that on the screen. And my WhatsApp number is 91, there's a plus sign, plus 91 9656058330. Thank you. Bye-bye.